Okay, everyone, a short video today. President Trump issued two new executive orders limiting birthright citizenship. And to the folks out there who assert he cannot do that, well, he just did. And when Joe Biden was president, he did the same type of thing all the time. Now, in my view, what President Trump is advocating here is really not that different from what Joe Biden tried to put in place in terms of regulating immigration. Okay, the Supreme Court or one of the federal trial courts would say to the president, you can't do such and such, and Joe Biden would turn right around and promulgate a rule that was essentially a workaround. Okay, a lot of people would accuse Joe Biden at the time of dementia for doing that, but I say he was being presidential in the sense of it's part of the presidential character, if I'm not mistaken, and it's part of the structure of our government. The president always pushes back, and I believe that as Americans, we all believe that the structure is good. We adhere to it not only because it's the law, but because it is good. So, the new executive orders from President Trump. Now, these are very well crafted and they respect the Supreme Court's recent decision in Trump v. Barbara. Now, a lot of skill and intelligence went into these orders. Principal among them, the executive branch understands that when the Supreme Court tells us no, they're not saying no to all things at all times. And when they say yes, what they're giving us could be quite minimal. Although we'll take the win. I mean, who wouldn't? Now, the two executive orders are quite different. The first identifies certain categories of children of aliens who are not entitled to birthright citizenship, consistent with historical exceptions to birthright citizenship recognized by the Supreme Court in Trump v. Barbara. So, this executive order is really a springboard from an exception already recognized in immigration law. The children of foreign diplomats born on U.S. soil are not U.S. citizens at birth. Now, to advocates of the concept of jus soli, which means right of the soil, how do you square this exception? The courts consider the children of foreign diplomats to be not subject to the jurisdiction of the United States, but in many ways they are. Now, if they're driving drunk and kill someone, they're protected from prosecution in the U.S. to some extent. Now, the home country has to waive their diplomatic immunity before they can be prosecuted. If the home country recalls them, they have to leave, but they could be extradited and returned to the U.S. for prosecution. Now, let's apply this principle to the categories of children of aliens specified in the executive order. For example, a child born on U.S. soil to at least one parent who's an alien enemy, a terrorist. Now, state sponsors of terror maintain legal and administrative jurisdiction over their operatives abroad, though they might deny it. So that means that a lie told by a state sponsor of terror forms the basis of our laws regarding birthright citizenship in that scenario. Come on now, that can't be right. And this is what I love about this executive order. It really gets specific about categories. If they're too broad, no rule can be applied meaningfully. Now, that was the problem with the initial executive order from January 2025. Now, here, the executive order denies birthright citizenship to children in a raft of different categories, but all regarding international jurisdiction. For example, if either parent is a foreign government employee, such as an ambassador, which is established law already, but for anyone else who possesses international immunity by virtue of their employment. Now, the executive order doesn't call out those organizations, but they might include the UN, the World Bank, and the IMF. And that's also what's so great about this executive order, because if there's a challenge, the person bringing suit has to challenge on the specific ground that impacts them. Now, just the UN or just the World Bank, etc. They cannot claim that there's a worldwide plaintiff class that's similarly situated, which is what they were doing with the last executive order in the Trump v. Barbara case. Now, that case must be limited to its facts, and it will be, which is what happens with all cases, with every Supreme Court opinion. So, when the Supreme Court says, and everyone born on U.S. soil is a U.S. citizen, what about the children of ambassadors? Now, that was already an established exception. Did the Supreme Court just forget about that one? Of course not. Does the Trump v. Barbara case now overrule the established exception? No one would argue that. And birth tourism is called out in the executive order. It calls out people who engaged in a commercial transaction or engaged in fraudulent activity to obtain citizenship. Now, I don't know if jurisdictional grounds will be used to justify denying birthright citizenship to such people, but this is a case where the executive power would be used by the State Department to deny citizenship on those grounds. And if they want to bring a lawsuit, it might be more trouble than it's worth to them. Do you know what I'm saying? They themselves could be arrested for trying to assert their alleged rights. Now, that's what I was referring to earlier. Sometimes the Supreme Court says yes or seems to say yes, but what the petitioner acquires is virtually impossible to establish, okay? They would have to go into court and they would be arrested for fraud immediately, okay? Most people who engage in birth tourism will never be able to benefit from it, okay? Even if this latest executive order is ever tested in court. Now, the second executive order recently issued delegates authority to the State Department and to DHS to halt birth tourism. So this might involve regulations. Now, this administration had looked down on regulations for a while, but they can be quite useful. Thanks for watching, and if you enjoyed this video, leave a like and don't forget to subscribe.